Good evening, everyone, and thank you for joining us for tonight's Rent Control Board meeting for Thursday, February 9th. Mr. Secretary, will you please call the roll?
Yes, Commissioner Gonska.
No, it's the one to the left. Yeah.
Here. Commissioner Gwynn.
Here.
Commissioner Ivanov.
Here.
Vice Chair Leslie.
Here.
No, it's this way.
Here.
And Chair Foster.
Here. Thank you so much. You might make note that our Executive Director, Tracy Condon, is absent tonight, and we are carrying on, even though it's hard, and we miss her. If you all will take a moment and review the minutes. Oh, yeah, almost forgot the pledge. Please join us in the salute to our flag. Thank you, Lon. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Now, I'd love to entertain a motion to approve the minutes from our last meeting.
So moved.
Is there a second?
Second.
I've had a first and a second. All those in favor of accepting the minutes, say aye. Aye.
Aye.
All right. There are no special agenda items this evening. This is the portion of the meeting where normally our executive director would just make general announcements. I would only add to the unofficial announcements that we are still receiving 100 to 150 calls a day regarding Measure RC. So if anyone out there does have any confusion, landlord or tenant, about what your rent level should be, please feel free to call our agency. Our information coordinators are there to help you and with your specific address and your specific case, and if need be, help you connect with your landlord. So we don't have any other special announcements from staff? Okay, seeing none. We'll move on to item 7, which is the public comment portion of our meeting. And we do have a few requests to speak tonight. And I would just remind you that public comment, we cannot take action on any of those items as they were not agendized for the public to see ahead of time. And these are comments that should be restricted to things that are within our subject matter jurisdiction. I have Jay Johnson, Michael Millman, and Jean Martin in that order. Good evening, Mr. Johnson. When you're ready, you'll have 3 minutes to speak.
Good evening. I believe you can hear me all right?
How do we turn his mic on? Do I have a control for that? Podium.
Is the mic on now?
It sure is. Thanks for our pay. We have a new system up here, so thanks for your
It's new
patience.
for me too. I'm used to the old 2-minute rule. So welcome everyone and greetings. My name is Jay Johnson, representing Progressive Landlords of Santa Monica. I was a rent board commissioner for 10 years sitting in those seats and been through the procedure. So welcome and congratulations to all of the new rent control board members on your appointment and your election to the rent board. We as progressive landlords come with our hands outstretched to ask you to work with us for win-win solutions to protect our tenants and the housing structures in our city. The primary purpose of both the Rent Control Board and landlords is the protection of tenants and the physical structures in which they live. Housing structures are aging here in the city, some built from the 1920s. They need repipe, re-roof, termite fumigation, and earthquake soft story retrofits, and numerous other refurbishments, maintenance, repairs, and city-mandated improvements. Without raising rents on existing tenants, we realize the best avenue to pay for repairs, etc., is to reduce costs of operating the old buildings before new buyers attempt to Ellis the buildings and displace numerous tenants. Prior to the COVID virus, Assemblyperson Nazarian, with the support of our state senator Ben Allen, had proposed a bill providing temporary property tax reductions for mandated earthquake and soft story improvements and balcony safety upgrades. The bill was postponed due to virus issues. It needs to be reintroduced. please agendize a letter to Assembly Member Zabur, the new Assembly person, and Senator Allen to support the Rent Control Board, showing support for the Rent Control Board for this win-win solution. We as progressive landlords look forward to meeting each of you for coffee, sharing ideas and working together to improve the housing experience in Santa Monica. We have more in common than you may realize. Some people have said that you will ignore this request. Help me prove them wrong. Thank you very much.
Thank you, Mr. Johnson. Michael Millman, when you're ready, you'll have 3 minutes.
Good evening. Mike Millman, 2100 Sawtell Suite 105 in West LA. So Jay and Matt said, why don't we come down to the rent board and introduce ourselves as progressive landlords? Look, I look at this mechanism as a two-legged bar stool. One leg we all agree on. Let's protect the tenants. And the other leg has to be, we need to support, if possible, the owners so they can be viable and stay in business. Let's take a small peek at history. We had the coronavirus, and it was only our community of landlords that took a haircut. Our rents were what? Reduced. We had high vacancies. And then, of course, if someone didn't want to pay, of course, there was no certification that we could authenticate or confirm. It was self-certification, no way to see if someone was gaming the system or fraudulently making a claim. We couldn't remove them by the only tool we had, which is eviction, and that's gone on for 3 years. Something to think about. I reached out to this board, not the board here, and I said, I need help. I've got vacancies. I'd like to discount the rent for the first several months to get them in to compete with the Palisades or Brentwood or something. I got ice in the wintertime. I got ignored. When my tenants ran out of quarters, I called to this group to say, go to the parking people and get me some extra quarters for the tenants for their laundry. Again, ignored. I go with Jay. Let's meet from time to time on issues that we can work on together that doesn't violate the Brown Act and see if there isn't some common areas that we can work on. My people don't believe in evictions. I don't believe in removing people. I don't believe in perpetrating fraud, saying I'm going to move into the unit and leave in a few weeks. Those are not my people. I want those mom and pops that inherited those units from their families, from their grandparents, to be able to have sufficient funds to manage them so that they can give them on to their children. I just want fairness. I just want an even playing field. We haven't gotten it before. It's not right. So I come today saying, it's a new page. I'm not going to be up here banging my chest anymore saying that you're a rubber stamp from SMER. You won't ever hear that again. But what I am saying is give us a chance to have an outreach. Show me your programs. Maybe we can adopt them and endorse them and promote them. Thank you for your time, Madam Chair.
Thank you, Mr. Millman. Okay, next we have Gene Martin. Sir, when you're ready, you'll have 3 minutes to speak.
I'm ready. Thank you. Good evening, everyone. Thank you for this opportunity. Not to confuse everybody, my name is Gary Eugene Martin. So the paperwork you're going to see is going to have Gary on it. So I didn't want you to be confused. And I also apologize. I didn't know it was a 4:30 time limit to get a package into you. So, but this gentleman over here has one for each one of you. What I'm here for is very simple. I have an exemption that was granted to me by the Santa Monica Rent Control Board and by the City of Santa Monica. I was granted this exemption in 1993. In this package, you'll see my renewal. I have to send in a affidavit every year telling me I'm still owner-occupied property. I am an owner-occupied property, income property owner. Right now, my problem is simple. The Legal Aid Foundation of Los Angeles, located here on 5th Street in Santa Monica, is telling me my exemption is not worth the paper it's written on. Along with the nonprofit organization St. Joseph Center in Venice. They're both telling me this doesn't mean anything. And I'm here to find out if you're telling me the truth. I expect for you to tell me the truth. If this is true, then I've been sitting on something since 93 that didn't mean anything. If it's not true, then I expect for you to get your crew and go down on 5th Street and tell this Legal Aid Foundation to back off and let my process take place. Thank you.
Thank you so much. And Mr. Martin, I assume you are in contact with our staff during business hours. Is that correct?
Yeah, I will be, and if you need me, on page 7 of your package is my contact number.
Okay. Thank you so much.
Hopefully somebody will give me a call and give us
most
the help to
certainly.
save our property. Thank you.
Thank you, sir. Okay. Seeing no other public comment at this time, we will close item 7 and the public comment portion of our meeting. Moving on, we will go to item 10, jurisdictional items. We have item 10A, an owner occupancy exemption, case OOEX 31398 for 2922 Highland Avenue. The applicant is M. Donahue, owner. We have a staff report, please.
Certainly. Good evening, Commissioners. Ms. Maureen Donahue bought this property, 2922 Highland, in June 2022, and she co-owns it with Mr. Kevin Sutherland, and each have a 50% ownership interest. The property only has 3 units. To qualify for the exemption, besides the fact that they have to have 50% ownership interest, and there has to be at least 3 or less units on the property, the landlord has to be able to prove that they lived on the unit for at least 120 days prior to the filing of the application as their principal residence. Ms. Donahue does own an investment property in Valencia, California, but she submitted leases to show that the unit, which is a townhouse, is rented to tenants. She also submitted utility, financial, and government records that all show her as living on the property since at least July 26, 2022, which is in excess of 120 days prior to the filing of the application. And staff also sent letters, tenant response forms to all the units in the property. The 1 unit that is rented, they returned the form, and they also confirmed that Ms. Donahue resides on the property. Therefore, staff recommends that the board grant the exemption and adopt the attached findings of fact and conclusions of law.
Thank you for that report. We have no request to speak on this item. Does anyone have any questions or comments? Great. I will entertain a motion.
I'll make a motion that we grant this exemption and adopt the findings of fact and conclusions of law.
Second from anyone?
I second the motion.
Thank you. We have a motion and a second to grant. Will you please call the roll?
Commissioner Gonska,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Ivanov,
Yes.
Vice Chair Leslie,
Yes.
Chair Foster.
Yes.
Motion carries.
All right. Moving on to item 10B, we have an exemption for new construction, case number NCEX 31663, 1015 Georgina Avenue. The applicant is O. Muhammad, owner. Can we have a staff report on this item, please?
Yes, Commissioners, Mr. Mohammed and his wife have filed an application to exempt this property, this single-family home on this property as new construction. They bought the property in 1990 as a single-family home and have lived there ever since as their family residence. Building records confirm that the prior owner, Ms. Monique Chemtob, had constructed a single-family dwelling on the property in 1986. A unit is eligible for a new construction exemption if it was built after the enactment of the rent control law and is not otherwise subject to the law through another basis, such as an Ellis removal or an Ellis withdrawal or a removal permit. None of those apply in this case, and therefore the staff recommends that the board grant the new construction exemption for the single-family home.
We have no request to speak on this item. I'm going to open discussion. Would you mind just highlighting for the board and for the public the history of these types of cases and these types of exemptions? When it appears to be a single-family home, you might be wondering, why are we even hearing this?
They had not applied for this exemption since they had purchased the property. We actually determined that the owner had not been residing on the property through our exemption monitoring because the prior owner had obtained an owner occupancy exemption for this property instead. And once we found out that the owner had sold the property and we lapsed that exemption, then the Mohammeds got in touch with us, and that's how they wound up applying for the new construction exemption.
I'm going to back you up one step farther. What was the rental unit on the property?
The rental unit on the property had been previously, there had used to be 2 units on the property. 1 unit had been demolished and replaced by that single-family home. What had been left was a bootleg unit, that bootleg unit, when the owner had obtained the owner occupancy exemption, they worked with the building department and they actually got rid of the bootleg unit. So all that's left on the property is that newly constructed single-family home, which is why the case is before you in this manner.
Great, thank you so much. Any other questions or discussion from board members? All right, I'd love to entertain a motion on this item.
I move that we grant the new construction exemption.
Do I hear a second?
Second.
I think you just beat you to the punch. Seconded by Commissioner Gonska, moved by Commissioner Ivanov. We have the roll call, please.
Yes, Commissioner Ivanov,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Gonska,
Yes.
Vice Chair Leslie,
Yes.
Chair Foster.
Yes.
Motion carries.
All right, moving on to item 10C, an appeal. Item N0282, 1248 Princeton Street, Unit A, T. Vanson, tenant. Can we have a staff report, please?
Certainly. Commissioners, the landlord in this matter filed a tenant not an occupancy petition under Regulation 3304. The board adopted this regulation because the purpose of the rent control law is to alleviate the impacts of the housing shortage on housing affordability by controlling the price, the rent of the unit where a tenant actually lives, not by controlling a secondary residence. And under this regulation, if a landlord believes that a tenant is not actually living in the unit and is only using it as a secondary residence, they can petition to find the tenant not an occupancy, and the rent can be increased based on recent market rates. To prevail, the evidence must show that the tenant is no longer using their unit as their usual residence of return, as that term is defined in the regulation through evidence under various listed factors, such as where the tenant conducts basic living activities, what address the tenant has been using for their mailing address with government organizations or with utilities, and where a tenant's personal possessions are located. In this case, the record shows that Ms. Vanson relocated to her then fiance's home in Montecito, California at the outset of the pandemic when the state issued its shelter-in-place orders. The record is also clear that Ms. Vanson had not moved back into the unit after 2 years subsequent to the pandemic's onset. And in the appeal that's filed and in the written responses filed by the tenant confirms that they still have not moved back. But under this regulation, even if a tenant has been absent for an extended period of time, there are certain reasons listed for extended absences which are excused by the regulation. And these are things like seasonal employment, travel for work, military service, or emergency care of family or friends. Ms. Vanson didn't submit any evidence under any of these factors, but instead she states that she has not moved back because her unit is uninhabitable. The hearing officer acknowledged that even though uninhabitability of a unit is not listed as a reason for excusing an extended absence it is reasonable that if the conditions of a unit are severe enough to render it uninhabitable, that the tenant would still be absent. The record in this case shows that just prior to the pandemic, the heater in Ms. Vanson's unit stopped working. Code enforcement issued an order determining that the unit was uninhabitable because it lacked basic heating, and ordered a temporary relocation, basically ordered the landlord to provide funds or otherwise to temporarily relocate the tenant. And Ms. Vanson actually decided to forego the temporary relocation and stayed in the unit. Once the wall heater was fixed, the code enforcement determined that the unit was no longer uninhabitable and lifted the temporary relocation order. It was only and that was on March 11th, 2020. It was only after the relocation order had been lifted, however, that Ms. Vanson relocated to Montecito because of the onset of the pandemic and all the issues that you recall back in March 2020. The record does not contain any evidence subsequent to her relocation of a government agency having found the unit to be uninhabitable. Therefore, the hearing officer found that Ms. Vanson has been not absent from her unit for over 2 years, that she didn't provide any reason, any evidence for any of the listed reasons for an excused extended absence under the regulation, and that no government agency that enforces health and safety codes had found the unit to be uninhabitable, and therefore granted the tenant not an occupancy petition and adjusted the rents. The board reviews this matter as an appellate body, and as an appellate body, it should affirm the decision if the decision and its findings are supported by substantial evidence. Because substantial evidence in the record supports the hearing officer's decision, staff recommends that the board affirm it and its findings of fact and conclusions of law.
Thank you very much. Before we proceed to the comments, do board members have any questions for staff about the staff report before we hear from the public? Seeing none, we will go ahead and hear from the parties. First up, I have Talia Vanson, followed by Peter Melnick. Hi, when you're ready, you will have, let's see, where is the podium mic on? You'll have up to 5 minutes. You don't have to use the whole, but if you want to, you can.
Trust me, I'm going to.
Okay. And also, please limit everyone who are parties to the actions, please limit your comments to things that are in the record or about the record. We cannot introduce new evidence as an appellate body.
Okay. First of all, thank you very much. I truly appreciate the board giving me an opportunity to appeal this decision. I'm a little nervous, so forgive me. I'm going to read some notes, okay? So basically, I've been a tenant in my apartment, 1248 Princeton Street, since 1996. Things were fine when I first moved in, but then things changed because one of the reasons with rent control, the fact that I was subject to the grandfather law that became different after 1999. I tried for decades to get the landlord to make repairs. I pleaded with him, and only to get a very unpleasant response, to say the least. And I learned through the time that unless it's really urgent, like for example with my kitchen ceiling caved in, to not asking for anything. For example, not urgent was a non-workable bathtub. That I did not have a bathtub working for 7 years. So when March 22 shelter-in took place, I'm just going to mention a few things. My apartment had not been painted since I first moved in. My oven was not usable. My bathtub, I couldn't use it. My toilet was loose on the foundation. I had holes in the walls. I had 2-inch hole in my street facing the front door, which is the people, and I covered it because people could come in, and I had a homeless guy that kept looking into my apartment. I had broken window safety locks. So I did not feel safe. And obviously, you would ask yourself, why did I stay in all this time? I did stay for various reasons. One of them, yes, was rent control apartment. But the other thing is I love Santa Monica. My work is here. I'm a creative producer and an artist. I work with a lot of nonprofits, Save a Child Heart, Wounded Warriors, GLAAD. And my social is here. Everybody I know is in Santa Monica. And also now, I view it as a classic abuser-abused relationship. And I did what a lot of women do. I stayed. So things changed when the pandemic came in. I felt not safe. I couldn't cook. It was shelter in. I didn't feel safe living in my apartment. Now, nobody knew how long Corona is going to happen. So I temporarily relocated to Montecito. At the time, I just wanted to fix Peter Melnick, who's not my fiance, he was my boyfriend. Corona continued and no one knew how long it's going to be. A few months after that, Peter proposed to me, but we never saw our marriage in a conventional way. We both married in a much later years, even if you might think I'm 20. No, I'm joking. But anyway, everything in my life fell apart everything in my life, apart from Peter, was Santa Monica. And also, here's one thing. I've been an independent single woman for my entire life. And now that I'm married, I don't want to be penalized for it and thrown out of my rent control apartment because my husband lives in Montecito. And because someone might think that marriage means I should be like living there too. So as the pandemic continued, I realized I had to do something because I really wanted to go back to Santa Monica. So I sent the landlord a lengthy repair lease in November 2020 and another one in April of 2021. Then on April 2021, I came to check my apartment and it was a plumbing issue. The water backed up from the bathtub to the bathtub from the toilet, from the flush toilet. The landlord repaired it, but he accused me of basically putting tampons in it and basically accused me for causing the blockage and told me to pay for it. He knew I wasn't living there because I told him when sheltering started place that I could not stay there. But he ignored that, claimed he saw lights in my apartment at night. I proved that I lived there. When that happens, I realized there's no way to work with him. So in mid-April 2021, I hired an attorney to try to get the repairs done. It was the first time in over 25 years that I felt that I had some kind of protection. 2 months later, he filed a petition claiming that exactly the opposite, that I hadn't lived in Santa Monica since May 2018, which he knew was false. Decision rejected this.
I'm sorry, that's your time. If you'd like to finish your thought.
Is there any way I can ask you for another minute and a half?
I'm sorry, we have 5 minutes to make that.
But there's some major things that I'm so sorry. I totally understand.
So what we could potentially do is if the other speaker wants to donate time, couldn't Mr. Melnick donate time to her?
No, at this point it's 5 minutes and 5 minutes. Everything is in the record, and so you have all the record for you.
Can you turn your mic on if you're going to make comment? Yep.
The commissioners have access to the record. Each party is allowed 5 minutes only. Very sorry.
I know there's a way that there's especially if I can ask for.
Ma'am, I did say you could finish your thought and wrap up for a few seconds. That is something we sometimes grant, but no more than that. Please feel free to go ahead.
Okay. There is, unfortunately, with all respect to Ms. Bowles, basically her decision is not describing the whole facts. And I know basically there is a structural problem here because the staff report is based on a decision, not the hearing records. And it's
Thank you so much for your comments. We have to follow the rules. I'm so sorry. I know you have more to say, but that's your time. Thank you very much. Mr. Melnick, you have up to 5 minutes.
Okay, I thank you for the time, and I have to say this was a 6-day hearing, an extremely complicated matter, and it is incredibly hard to even attempt to get this done in 5 minutes or even 10 minutes, but we'll give it a shot here. I'm going to make a few comments beyond what my wife offered. Picking up where she left off, the use of the word uninhabitability has a lot's been talked about it. When she began this process, she did not understand.
It's listed as the 5-minute box is checked on the chip. I was just going by that.
I just want the board to be aware, this is the same party, this is not the owner.
Right.
This is the tenant's husband.
So it should be 3 minutes.
Correct, the board can go ahead and hear it, but just be aware that this is the same side.
Right. So the parties are the tenant themselves and the owner themselves. So you can have up to 3 minutes to speak. And I understand if we messed up your flow, we can start it over.
I appreciate that
I
very much.
think we can accommodate that.
Thank you for that kindness.
You're welcome.
Regarding the word uninhabitability, when Talia began to use that word, she didn't understand that it's a term of art that must be defined and qualified. What she understood it to mean is decrepit, broken down, a place you wouldn't want to live in and you shouldn't have to live in. She didn't understand that at the time, and unfortunately, she didn't even understand it going into the hearing. When in April of 2021, she decided to seek counsel to help her persuade the landlord, compel him to perform repairs, which was very important to her. The counsel, unfortunately, did not counsel her, did not advise her on the correct use of the word, so she continued to use it informally. Had she known, she certainly wouldn't have predicated her response in this hearing on the use of that word. If you understand it to mean the place was really difficult to live in, it makes sense. She also didn't understand that there were other options that she could avail herself of to get the landlord to perform, such as a notice to repair or restore. She learned of that at the hearing, in fact. What I want to go on to say is that first, there were serious errors in the decision itself. There were errors of misstating testimony. Mr. Ayubi, for example, was a handyman working for the landlord who testified that in April of 2021, when he was there, he observed an apartment that was denuded of any personal objects. Under cross-examination, he was shown photographs that showed an apartment with clothes, with personal objects, effects, books, all kinds of stuff. He walked his statement back rather awkwardly and said, it's 8 months ago, I don't know what I saw. That's not a quote, but Ms. Bolds, in summarizing it, only referred to what happened under the examination, nothing of what somewhat impeached him in the cross. A more serious error, however, she made a statement regarding the landlord's response to repairs that was glaringly wrong. She said, quote from page 2728 of the report, "The record does not reflect a history or pattern of management failing to respond to repair requests. As Talia has expressed here, there is a long history exactly about that. The fact that that wasn't supported in her decision tends to nullify an argument that she put great time into, which was that this landlord has pursued constructive eviction in many respects, including harassment. She ignored, I see my time is almost up. I'm going to jump ahead to something else. The problems with this decision can't be found in looking at the decision itself. And that's the problem with the staff report. The staff report reports what was in the decision. The problems can be only detected if you look at the gap between the decision and the actual record. That's not an easy thing to do. But in the interest of justice, that's what I think must happen here. So I hope that Talia has made a case for reversal. But if not,
Thank you for your comments. All right, the next two speakers are Linda Kim, attorney for the petitioner, and Andreas Ionis. So one of the two of you can have 5 minutes. Which one of you wants the 5 minutes?
I don't think that I'll need all 5 minutes, so.
Okay.
I'm
Go-
going to
go ahead.
start, and then if I do have a few minutes left, then I'll reserve for rebuttal, but I'll allow my client to have the 5 minutes. Good evening. My name is Linda Kim, and I represent the owner. We very much appreciate and agree with the staff report recommending that the board affirm the decision of the hearing officer that there is substantial evidence in the record to reasonably support the hearing officer's approval of owner's petition, finding that Ms. Van Son is a tenant not in occupancy. And you heard Ms. Van Son speak about specific testimony and the details. We submit to the record in this case, which is extensive and large, is significant, probably more than half of it was regarding the habitability issue. And the record will also reflect that Ms. Van Son throughout the process was represented by capable counsel, who is not present today. And in a case like this, and in this case, it's not a situation where it's he said and she said. And I'll submit that my client disagrees with almost everything that Ms. Van Son said. But instead of going through and rebutting each of those comments, what's critical is there was additional evidence that that is neutral, that was presented. And this is evidence that Ms. Bold properly relied upon to come to her decision. And specifically, the code enforcement officer, Mr. Blanco, testified, and again, this is even before she moved out of the unit, regarding the heater repair. He testified that the time that it took the landlord to make the repair and reinstall a brand new wall heater, which required permitting during this is pre-COVID time, was really good time frame. Again, you know, we have the city's own employees saying that the repairs are made in a timely manner. Also significant is that there is no evidence of uninhabitability determination during the relevant time period, whereas there was plenty of evidence that Ms. Van Son in the past had gone to code enforcement, had gone to the county to try to complain, had called the city attorney's office, yet there is no evidence, no record that any of those were followed through by any of those agencies. So that's all I have. Thank you.
Thank you for your comments. Does anyone have any questions for any of the parties at this point? Thank you so much. And the next speaker is, forgive me if I mispronounced your last name, Andreas Ionin? Close enough. Close enough. All right. You may start when you're ready.
Hey. Hello, everyone. My name is Andreas Iwanu, and I am the co-owner and designated property manager of 1248 Princeton Street. I'm also the petitioner in this matter. I want to start off by thanking the Rent Control Board for its time and resources throughout the entirety of this process, which included 6 days of hearings and a great deal of administrative attention on the back end. I also want to thank the board for its time today. I agree with the findings of the hearing officer's decision, the subsequent staff report, and the supplemental staff report. I feel they are a fair and appropriate reflection of this case. 1248 Princeton Street is a fourplex that has been owned by our family since 1987 and is near and dear to our hearts. Since 1987, my family has put a tremendous amount of work into the building, ranging from drought-resistant landscaping improvements to new electrical, repiping, new roofing, new flooring, and weatherproof windows. In addition to my duties as an owner and property manager, I am a lifetime LA resident and have worked full-time locally in healthcare, including in Santa Monica, for the past 10 years. At the onset of the pandemic, I was also part of a local health system's COVID task force and am knowledgeable of its impact on our community. I filed this petition back in June of 2021 after it became abundantly clear that Ms. Vanson had stopped living in the unit. This fact is uncontroverted by either party. Unit A is a ground floor unit that is closest to and most visible from Princeton Street. During my frequent visits to the building over the last 3 years, the unit constantly appears pitch dark and obviously empty while the other units are lit up. Throughout the day, Unit A's blinds are completely shut with no fresh air or light entering the unit. I am constantly removing advertisements that are placed on the unit's door, as when these flyers are left for long periods of time, they serve as one of many signals to prospective squatters, vandals, and thieves to target the unit. In fact, during the first year of the pandemic, we had a tenant and neighbor report suspicious people congregating in front of the unit during the late hours of the night. As stated in the hearing officer's decision, this led us to installing surveillance cameras in the common areas of the building to help deter trespassers and protect the building. Since installing the cameras, we've observed suspicious people attempting to peer through the window of Unit A, knock on and attempt to open the door, and even transients using the hose next to the door to bathe. Ms. Vance's now nearly 3 years absence from the unit continues to pose serious security and safety concerns to the property, its other residents, and our neighbors. In our continuing efforts to fend against additional risks to residents and potential damage to property created by Ms. Vanson's 3-year absence, we've had to increase our efforts in monitoring and safekeeping the property. My family fears it is only a matter of time before we have a break-in resulting in a squatter situation, or even worse. There is also substantial concern that if an emergent issue occurred in the unit, i.e. bursted pipe, gas leak, etc., nobody would be present to report it, resulting in serious risk to the neighboring tenants and significant damage to the property. We have no issue with Ms. Vanson continuing her tenancy at the property. We are happy that Ms. Vanson found love and happiness in living in Montecito with her husband of 2 years in his $9 million home. However, there are rules and regulations in place for rent-controlled units, and her decision to move out of Unit A and into her husband's home conflicts with Regulation 3304. If you have any questions, I am happy to answer them, and if not, I thank you for your time. Thank you.
Thank you for your comments. All right, we have no further requests to speak on this item.
Chair, I'm very sorry.
Yes, Counsel.
I went and reviewed the regulations. The majority, if a majority of the board votes to allow a speaker more time, you can do that. So I wanted to make sure you knew you had that option.
Yes. And typically the chair will respond to her colleagues if they wish to allow it. Otherwise, then I took the lead to allow her to finish her thought, and there was no other discussion of it. So I'm comfortable with the way we proceeded, but thank you for the clarification. All right, we're going to enter discussion now, and if you guys want to make comment on this case, now is the time to start. We have Commissioner Gwynn first up in the queue.
So first of all, I want to applaud the hearing officer in this because of the amount of work in this. On the surface, these kind of cases look like they should be a slam dunk, easy thing to do, but as we see in this one, they become very complex because of underlying tones that move into this, and for a 6-day hearing to do this, and also the fact that she brought into play things that weren't specific in the regulations, such as a reason for a absence from a unit, and in this case it was the pandemic, which obviously is an obvious reason that would be accepted based on the regulations. And while that is a reason, there has to be an end game in that situation. COVID was a reason for her to be gone for quite some time in this case. And however, there has to be an end game. And I think the proof or the evidence that was brought up in this case proved that she was not occupying the unit during this period of time from March of 2020 through to current. And she herself, Ms. Vanson, said in her testimony in the hearing that she was not living in this unit. So I think the evidence and her comments support that. I think where the problem becomes, and we heard this over and over in both in this hearing officer's decision and in the rebuttals from in the tenant, Ms. Vanson, that habitability is a word that keeps coming up in this situation. And therefore, I think the only thing that she has come to rely on is this as a reason for her not returning to her unit. And I understand that maybe she didn't understand the reasoning, what habitability means as far as it comes down into a hearing like this. But like any law, just because you don't understand it or you don't know about it doesn't excuse you from obeying that law. And in this case, while there was a point where it was uninhabitable, this was before March of 2020. And since then, the unit is habitable as far as any government agency and any law says. And I fully understand there may be maintenance issues in this unit. There may be. But that doesn't make the unit habitable unless it's proclaimed uninhabitable. That word is amazingly hard to say numerous times. So because of all that, unless other commissioners have other reasonings, I just can't find any reason that we wouldn't uphold this, deny the appeal and uphold the petitioner's request.
Thank you for that. Anyone else? No? Okay, I'll go. Because I feel like this is an important type of case, and it's always a learning opportunity for the public, especially to educate themselves and for us to do our job thoroughly. Can staff tell us just a bit about what happens during the time period a landlord is making their prima facie case that a tenant might not be in occupancy? My question is there an opportunity to cure, or is it just the past? And if the past is provable, then the hearing officer is compelled to find in favor of the petitioner.
So the way that the prima facie aspect of this process and the whole process works is when the landlord submits their petition and they submit the documentation that the evidence that they have with the petition, then the hearings department staff reviews that application to see if there's a prima facie case to be made. If the evidence, if you take it as it is sufficient to prove the matter that's being sought. And that's exactly what happened in this case. And then the matter is scheduled for, the parties are notified, the case is accepted for filing, and the matter is scheduled for mediation usually, and then for a hearing if things aren't resolved in that manner. In the context of a tenant not an occupancy petition, it's quite factual. It depends on what exactly are the reasons. And this board, prior to this one, including when you've been during the time that you've been here, you've seen various versions of facts that come here. Mm-hmm. Some people have been away because they've been taking care of other people. There's all kinds of reasons for which people are not in a unit. And so those are analyzed under the factors that are listed in the regulations, including the factors for an excused extended absence. So that's the approach and the basic contours of this process as far as a tenant on an occupancy petition.
Thank you for that clarification. I find that helpful. There's no doubt in my mind that a lot of long-term tenants don't get treated exactly the same as market rate tenants in some cases. Not all, but in some cases. I've seen it. Other advocates have seen it. But it is not a basis to declare in your own view whether something's habitable or not habitable. We do have petition processes, and it's the only tool we have to offer a tenant in that particular claim where you think there are things that are not what you contracted for or not in good repair, the petition processes we have for rent decrease petitions, that's all we have. And so if those are not, tenants and landlords both have a responsibility to understand our charter and our processes that we have. And so it's really tough when we see a tough case, but both parties have to familiarize themselves with the law. And like Commissioner Ivanov said, if you're driving down the road and a cop pulls you over and says, well, you were doing 40 and a 30, you say, well, I didn't know it was a 30. I didn't see any signs. It's not a defense in court. So tonight, what we're here to do is to decide if there was clear error or not in the hearing officer's decision-making process. And I agree with Commissioner Gwynn that I can find none. There was no clear error in this decision and no basis for me, in my opinion, to change what we see in the staff report and in the findings of the hearing officer in this case. Seeing no other comments, would anyone like to make a motion? Commissioner Leslie.
I move that we uphold the previous ruling
And deny the appeal.
and deny the appeal.
Do we have a second? I need a second.
Second.
Okay. We have a motion and a second. Thank you. We call the roll, please.
Yes. Commissioner Gwynn.
Yes.
Commissioner Ivanov.
Yes.
Commissioner Gonska.
Yes.
Vice Chair Leslie.
Yes.
Chair Foster.
Yes.
Motion carries.
All right. Item 15 is listed as written communications. Those are essentially letters that have been written to us by the public on matters that are within our jurisdiction area. They are just to be treated like public comment, like anything else. Those are available for the public to read if they so choose, but that's all we're going to say about it here. And staff will respond to written communications. That's it, folks. Our next regular meeting will be Thursday, March 9th at 7 p.m. in this chamber. And we hope to see members of the public there who want to learn about the rent control law. Can we entertain a motion to adjourn?
I make a motion to adjourn.
Second.
All right. All those in favor?
Aye.
Aye.
We are adjourned.
I know, I see.